The traffic stop began at 7:41 in the morning. It was a Wednesday in October, and Judge Harold Eugene Beaumont was driving his 2019 navy blue Buick Enclave on the Meridian Expressway toward the Callaway County Courthouse, where he was scheduled to preside over the opening of the criminal docket at 8 o'clock. He had been driving this route for 14 years. He drove it the same way every morning that court was in session, meridian south from his home in the Fairview neighborhood, the left at Caldwell Street, the public parking on 9th, 4 blocks to the courthouse. He knew the lights. He knew the intersections. He left at 7:30 every court day without exception because the 8 o'clock docket waited for no one, and he was not the kind of judge who started late. He was 63 years old. He had served on the Callaway County Superior Court for 14 years. Before that, he had spent 11 years in private practice, primarily criminal defense, with a period in the early years where he had taken court-appointed cases at a rate that had made his partners uncomfortable, and that he had continued anyway because the work was necessary and he was good at it. Before that, he had spent 2 years clerking for a federal appellate judge whose approach to the law, rigorous, unsentimental, and fundamentally committed to the principle that the law must apply identically regardless of who is, before it had shaped every year that followed. He had been appointed to the bench at 49 after 11 years of practice and a reputation in the county legal community that had preceded the appointment by several years. He had been confirmed by the state Senate with a vote that was at the time the most bipartisan confirmation of any judicial appointment in the county in a decade. He was a large man, 6 feet 1, broad-shouldered, still carrying himself with the specific uprightness that he had learned in 2 years of Army ROTC before law school and had never quite shed. His hair had gone entirely silver. He wore on court mornings a dark suit, his black judicial robe folded and hanging in the back seat of the Enclave for quick transition at the courthouse. He had grown up in the Millbrook neighborhood of Callaway County, in a house on a street that had once been a good street and had become a complicated street, and had remained his street regardless of what it became, because his parents lived on it and his mother still lived on it, and when he drove past it on Sundays, he felt the specific combination of pride and grief that attaches to the places that made you. His father, Walter Beaumont, had worked for 41 years as a mail carrier. He had walked his route in all weather every day, and had retired at 66 with a body that had done 41 years of walking and felt every one of them. He had been a man of specific routines and specific expectations about punctuality, about documentation, about doing what you said you would do when you said you would do it, because the people who received the mail counted on it arriving when it was supposed to arrive, and anything less was a failure of the obligation he had accepted. Harold had absorbed this entirely. He had absorbed it so completely that it had become indistinguishable from his own character, which was the best outcome of a parental teaching. Not that you follow the rule, but that the rule becomes you. His mother, Adeline, had taught 7th grade English for 33 years at Millbrook Junior High. She had graded papers on the kitchen table on Sunday afternoons with a red pen and a cup of tea, and the red pen had meant something specific, that the work could be better than it was, and that getting it to be better required knowing precisely where it fell short and why. She had not been a warm teacher in the sentimental sense. She had been a precise one, which Harold had come to understand was a more demanding form of care. He had been the first person in his family to go to law school. He had told his mother when he was admitted that he wanted to be a judge. She had said then, be a good one, not a well-regarded one, a good one. He had not forgotten. He had served on the bench for 14 years. In those 14 years, he had presided over criminal matters, civil matters, family court assignments, and a period of emergency administrative duties during a natural disaster that had required him to convene emergency sessions at non-standard hours, in non-standard locations, and to maintain the integrity of proceedings under conditions that tested every skill he had developed. He had not once started a session late by choice. He had started late twice, due to circumstances beyond his control, and had documented both in his judicial log, and had briefed the presiding judge on both occasions, and had extended the session both days to ensure that every matter on the calendar received its full allocated time. He was 14 minutes from the courthouse. He had 19 minutes until the docket opened. The patrol car entered the lane behind him. He was driving at 61 miles per hour in a 65 zone on the Meridian Expressway at 7:41 in the morning. The patrol car entered the lane behind him. He watched it in his mirror. He watched it the way he watched everything in his mirror, with the specific attention of a man who has driven these roads for 40 years and knows what the presence of a patrol car behind him means for him, which is different from what it means for other people, and which has always been different, and which is a fact that he has never been able to afford to forget. He had a specific thought in the moment the patrol car appeared behind him. He had this thought, or a version of it, every time a patrol car appeared behind him. The thought was, be everything you actually are, and more of it, not less. Be more deliberate. Be more clear. Be more precise. Because what is going to matter in the next 30 seconds is not who you are in the abstract, but who you are in the specific. What you do with your hands, what words you choose, what tone you use, whether the person approaching the window has any opening to interpret you as anything other than exactly what you are. He had been having this thought or a version of it for 41 years. He maintained his speed. He signaled to move into the right lane. He moved into the right lane. The patrol car moved with him. The lights came on. He felt the specific feeling that had attended every stop for 41 years. Not fear exactly, though fear was present, but something more complex. The combined weight of the protocol and the knowledge of why the protocol was necessary, and the particular weariness of a man who has been excellent at everything he has done, and who still, at 63, in a robe that represents the authority of the court, still has to think carefully about where he puts his hands. He pulled to the shoulder. He turned off the engine. He placed his hands at 10 and 2. He had been pulled over 7 times in 14 years on the Callaway County bench. Each time he had followed the same protocol. It was not a protocol he had developed himself, though he had refined it over the years. It was a protocol that had been developed for him partially by his father, who had talked to him about it when he was 16, and preparing to get his driver's license in a conversation that Harold had understood intellectually at the time, and had understood in his body only after the first time he was pulled over at 22 in a rental car, on a highway in a state he did not live in, when the officer had arrived at his window already in a posture that Harold had recognized immediately and had been prepared for because of the conversation with his father. Hands visible. Engine off. Announce movements before making them. Speak clearly and without volume. Do not argue. Document afterward. His father had given him the protocol the way fathers give their sons instructions for navigating dangerous terrain, not because they want to, but because not giving it would be a greater failure of care. Harold had received it the same way, not as an injustice, because the injustice was not his father's to give or withhold, but as a tool, a method, a way of converting an inherently dangerous situation into one that was marginally less so through the application of discipline and the elimination of variables. He had been using it for 41 years. He had been pulled over 7 times in 14 years on the Callaway County bench. He had been pulled over 4 times in the 11 years before that. He had been pulled over twice in the 2 years of clerkship. He had been pulled over 6 times in law school more times before that, and the number before that was a number he had stopped keeping track of in his late 20s. Because keeping track of it was making him carry something he had decided he could not afford to carry and still do the work he wanted to do. He pulled to the shoulder. He put his hazard lights on. He turned off the engine. He placed his hands on the steering wheel at 10 and 2 o'clock, which is where he always placed his hands during a traffic stop, because he had developed over the course of his life the specific protocol of a man who understands that the 30 seconds after a patrol car stops behind him are the most consequential 30 seconds of any ordinary driving day, and that the correct behavior during those 30 seconds is not about guilt or innocence, but about survival, and about not giving the person behind him any reason, any opening, any ambiguity to work with. He waited. The officer approached. His name was Trace Elkins. He was 28. He had been on the force for 4 years. He was a compact man with close-cropped hair and the particular walk of someone who has been taught a physical presence and is conscious of maintaining it. He had no formal complaints on his record. He had a series of informal commendations for traffic enforcement for the high volume of citations he issued and the efficiency with which he documented stops. He was known in his unit as someone who worked quickly, who ran a high number of stops per shift, and who maintained, in the assessments of his supervisors, a clean record of officer behavior during those stops. He had been born and raised in a suburb 20 miles from Caldwell County and had come to the force after 2 years at a community college and a year working in a freight warehouse. He had wanted from early in his time at the college to work in law enforcement and had pursued the certification with the same focus he brought to other goals, efficiently, practically, with his attention on the outcome rather than the process. He had done well in the certification program. He had scored in the upper quarter on the written examination. He had performed well in the physical and tactical components. He had been hired by the department and assigned to patrol, and had worked with the particular intensity of someone who has decided that high performance in visible metrics is the path to advancement and has organized his daily work around producing those metrics. High stop volume was a visible metric. He produced it. What was not in his formal assessment was what was in the informal understanding of the officers who worked with him, that his stops were not random, that they were not based purely on observed traffic violations, that the distribution of who he stopped over 4 years told a story that no one in his unit had chosen to tell formally. Elkins had not made a conscious decision about this. That was the most accurate way to describe it. Not that he had decided to stop certain people and not others, but that his attention moved in certain directions, and not others. And those directions had an internal logic that he had never examined, because he had never been required to examine it. He had run 1,214 stops in 4 years. No one had looked at who he was stopping. Not until the morning of October 9th. He walked to the driver's side window. He said license and registration. He did not say, "Sir." He did not say, "Good morning." He said license and registration in the tone of someone who has already formed an assessment of the situation and is issuing an instruction, not initiating an interaction. Judge Beaumont said, "Good morning. May I ask why I was stopped?" He said it with the deliberateness he brought to everything clearly, without edge, with the specific composure of a man who has been in front of arguments and juries and colleagues and has long since understood that how you say something is as consequential as what you say. Elkins said, "I observed your vehicle traveling in the left lane without passing." Judge Beaumont said I was traveling at 61 miles per hour in a 65 zone and moved to the right lane when I observed your vehicle in my mirror. Elkins said license and registration. This is the moment. This is not the moment where things go wrong. Things did not go wrong. This is the moment where the specific quality of Harold Beaumont, of what he had built over 63 years, and what he carried in the car with him, and what he had decided decades ago about who he was in moments like this, becomes fully visible. He reached toward this glove compartment slowly and deliberately, announcing the movement. Before he made it, as he always did, as he had always done, as he had been doing since he was 22 years old, and had understood that the announcement of the movement was not a courtesy, but a necessity. He produced the registration from the glove compartment. He produced his license from his wallet. He produced from the interior breast pocket of his suit jacket his judicial identification, a laminated card with his photograph, his name, his title, and the seal of the Caldwell County Superior Court. He held all three out together through the window. He said, "My name is Harold Eugene Beaumont. I am a sitting judge on the Caldwell County Superior Court. I have court beginning in 19 minutes. I am not impeding your performance of your duties. I am simply letting you know the context so that we can proceed efficiently." He said it the way he said things from the bench, not warm, not cold, completely clear, completely factual, without a single word more than necessary. Elkins looked at the 3 items. He looked at the judicial ID. He looked at it for a long moment. Something shifted in his face. Not dramatically, not in the way of a man who has realized something and is reacting to the realization with visible emotion. In the more contained way of someone whose internal assessment has encountered a fact that does not match the assessment and is in the process of adjusting. He said, "I'm going to need you to wait here." He took all 3 documents with him to the patrol car. Judge Beaumont watched him in the mirror. He thought about the 8 o'clock docket. He thought about the 14 cases on the morning calendar and the specific cases among them that had attorneys who had traveled distances for this date, witnesses who had arranged their lives around it, defendants who were in custody, and for whom the morning calendar represented the next step in a process that moved at the pace of the court schedule and not any other pace. He thought, if I am late to my own courtroom, those people bear the cost of that. This was not an abstraction. He had in 14 years seen what it meant for a case to be continued because a witness couldn't make the rescheduled date. He had seen what it cost a family to have a hearing delayed when the hearing was the next step in a process that had already taken too long. He had seen defendants sit in custody past their scheduled release because paperwork had been delayed or a hearing had been pushed. He understood at a granular level that time in the legal system is not neutral. It accumulates costs for the people who cannot afford delay, and it does not accumulate those costs evenly. He was the person who was supposed to prevent that kind of delay. He was the person currently stopped on the shoulder of the Meridian Expressway with 8 minutes until the docket opened because a patrol officer had pulled him over for traveling at 61 miles per hour in a 65 zone. He thought, if I am late to my own courtroom, those people bear the cost of that. He did not think it with anger. He thought it with the specific clarity of a man who understands that the thing happening to him on this shoulder of this expressway has consequences that extend outward from himself in ways that he is responsible for tracking. He thought about his judicial robe folded in the back seat. He thought about putting it on. He decided against it. He thought about calling the courthouse. He called the courthouse. His judicial assistant, a woman named Margaret Crane, who had been his assistant for 9 years, and who had in 9 years encountered every kind of logistical emergency that a busy court calendar could produce, and had managed all of them with the specific competence of a person who understands that the judge's schedule is not the judge's alone. It is everyone who appears before the judge, and everyone who appears before those people answered on the second ring. He said, "Margaret, I have been stopped on the Meridian Expressway. I am going to need a few minutes on the docket." She said, "How many minutes?" He said, "I don't know yet. Let the parties know I am coming and that the delay is beyond my control. Do not tell them more than that." She said, "Should I call anyone?" He said, "Not yet." He said, "Margaret, who is on the morning docket?" She told him. He listened. He said, "The Watkins matter that attorney drove from Beaumont this morning." She said, "I know." He said, "Keep him informed specifically." She said, "Yes." He said, "I'll be there." He hung up. In the patrol car behind him, Elkins was running his license and registration and his judicial identification, and was having, based on what emerged in the subsequent investigation, a conversation with his dispatcher that began as a routine traffic stop and ended with Elkins being advised by a supervisor who had been notified by the dispatcher to exercise professional judgment about how to proceed. Professional judgment. Elkins had returned to the driver's side window after 11 minutes. 11 minutes. Harold Beaumont had been on the bench for 14 years. He had presided over thousands of hearings. He had read thousands of case files. He had reviewed evidence motions, appeals, transcripts. He knew what 11 minutes meant in the context of a traffic stop with no basis and no finding. He had seen the costs of such stops play out in courtrooms, had presided over cases in which the downstream of an unjustified stop had accumulated consequences for years. He had thought about none of that in the 11 minutes. He had thought about the 8 o'clock docket. He had thought about the attorney from Beaumont who had driven 2 hours and who was currently standing in the courthouse hallway being told by Margaret Crane through a message that went through the court clerk that the judge was delayed due to circumstances beyond his control. He had thought about the 14 cases and what 14 cases meant to the 14 groups of people waiting on them. He had thought about his father's hands on the kitchen table. He had sat with his hands at 10 and 2. Elkins returned the documents through the window. He said, "I'm issuing you a verbal warning for failure to keep right." Judge Beaumont received the documents. He said, "I'd like your name and badge number for the record." Elkins said, "Trace Elkins, badge 4471. Judge Beaumont wrote them on the small notepad he kept in the center console. Always in the center console. Always a small notepad. Always a pen that worked. He wrote the date the time the stop began, the time the documents were returned, the stated reason for the stop, the badge number, and the specific language of the verbal warning. He wrote it clearly. He wrote it in the same handwriting he used for bench notes. He said thank you. He put the enclave in drive. He arrived at the courthouse at 8:11. The morning docket had been held. The parties were present. The attorney from Beaumont was in the gallery. The defendants were in their seats. He entered the courtroom at 8:13. He walked to the bench with the specific pace of a judge entering a courtroom, neither hurried nor casual, measured with the particular deliberateness of someone who understands that the judge's entrance sets the tone for the session that follows, and that the tone needs to be one of complete control, regardless of what has preceded it. He took his seat. He looked at the courtroom, at the attorneys, at the defendants, at the gallery, at the court reporter at her station, at the clerk who managed the docket board with the expression he brought to the beginning of every session, present, attentive, without preoccupation. He said, "Good morning. I apologize for the delay. The matter before us this morning is the Callaway County docket for October 9th. Let's begin." He looked at the attorney from Beaumont who had driven 2 hours. He said, "Mr. Callahan, thank you for your patience. I understand you traveled this morning, and I appreciate that accommodation." The attorney said, "Of course, Your Honor. No difficulty at all." He had said it with the particular courtesy of an attorney who has been practicing long enough to know that a judge does not apologize for a delay without a reason, and who has decided that the correct response to an apology from a judge is to accept it graciously and move forward, which is also the correct response from a purely practical standpoint, because the case is still before this judge and it is wise to begin well. They began. He moved through the 14 cases with the efficiency that was his standard calling, each matter giving it its full allocated time, moving without waste from one to the next. He handled a contested motion in the 3rd case and a scheduling dispute in the 7th and a complex evidentiary question in the 11th that required him to take a 12-minute recess to review his notes before ruling. He ruled correctly. He knew he ruled correctly. He would not have ruled any other way. He finished the morning docket at 12:48. He did not mention the stop from the bench. He did not mention it to the attorneys during the morning session. He did not mention it to anyone in the courthouse. He wrote in his judicial log during the lunch recess. He had kept the log since his first year on the bench, the same kind of black hardcover notebook purchased from the same office supply store, replaced when one filled. He was on his 16th notebook. The first 15 were in a filing cabinet in his chambers, organized by year, labeled on the spine. The log was private, not part of the official record, not subject to discovery. He kept it because he had decided in his first year that the judge's private account of events was as important as the official record, and that the official record did not capture everything that needed capturing. He had documented in it procedural irregularities, conversations that had mattered, decisions he had made that he wanted to be able to explain, and the things that had happened to him personally as a judge and as a black man who held that title in a county that was still in many ways learning how to hold both facts at the same time. He had not until this morning documented a traffic stop in the judicial log. Traffic stops had been in a separate personal journal at home. He had maintained that distinction carefully. He was putting this one in the judicial log because the stop had affected his judicial service. It had delayed a calendar. 14 parties had waited. The distinction between personal and professional had been dissolved by the stop itself. He wrote the account in the judicial log, a private log he had kept since his first year on the bench, in which he documented anything that occurred during his judicial service that might have bearing on future matters or that he believed the record should contain. He wrote it in sequence. He was specific. He named Elkins. He recorded the badge number. He recorded the times. He wrote, "I was stopped on the Meridian Expressway for 11 minutes while traveling to preside over a court calendar of 14 matters. I produced my license registration and judicial identification. A verbal warning was issued for failure to keep right. I was traveling at 61 miles per hour in a 65 zone in the left lane. I moved to the right lane when the patrol car appeared in my mirror. I have been driving this route for 14 years. He wrote one more line. He wrote, "I have been stopped on this route or roads equivalent to it more times than I have documented in this log, because for most of my life I did not believe the documentation would be useful. I believe it is useful now. I am beginning to keep the record." He set down his pen. He opened the afternoon docket file. He had 12 cases in the afternoon. He began preparing. The complaint was filed through the court's administrative office and through the county's internal affairs office, not by Harold Beaumont, who had a specific relationship with those institutions that required him to navigate conflicts of interest carefully, but by his judicial assistant, Margaret Crane, who had 27 years in the county court system and understood both the appropriate channels and the appropriate language. Margaret had worked in the court system for 27 years. She had started as a filing clerk, moved through administrative roles, and had been Harold Beaumont's judicial assistant for 9 years, since the beginning of his second term on the bench. She had watched him manage 14 years of cases, 14 years of docket management, 14 years of decisions that were reviewed and appealed, and sometimes overturned, and sometimes cited favorably in subsequent opinions. She had also watched him navigate over 9 years the specific dimension of being who he was in the institution he worked in. She had watched without comment because it was not her experience to comment on, but she had watched with the attention of someone who understood that what she was seeing was real, and that her understanding of it was part of what made her useful to him. When he told her about the stop during the lunch recess, clearly specifically in sequence, she had asked 3 questions. She had asked what time did the stop begin. She had asked what time were the documents returned. She had asked was there any documented traffic violation. He had answered all 3. She had said, "I will file a complaint." He had said, "I appreciate that. File it in your professional capacity. I have a conflict of interest that makes it complicated for me to file directly through the channels that would be most efficient." She had said, "I know. That's why I said I will file it." She had not asked him if he wanted her to file it. She had told him she would. That was her understanding of what was necessary, and she had communicated it directly, which was the reason she had been his assistant for 9 years, and would remain his assistant for as long as he was on the bench. Margaret had listened to the judge's account during the lunch recess, had asked 3 specific questions, and had filed the complaint the following morning. She had filed it under her own name and her own professional capacity as an administrative officer of the court. She had titled it, "Complaint regarding traffic stop of sitting County Superior Court judge during travel to court with potential impact on scheduled judicial proceedings." The title was precise. Margaret had spent 27 years learning to title things precisely because the title of a document determines how it is categorized, how it is routed, and how seriously it is taken by the first person who receives it. She had watched documents land and disappear when titled vaguely and move through the system efficiently when titled with the specific language the system was designed to respond to. The complaint included the date and time of the stop, the officer's name and badge number, the stated reason for the stop, the documented speed relative to the posted limit, the time the documents were returned, and the specific fact that the delay had caused the postponement of a superior court docket affecting 14 pending matters. It noted that the officer had been in possession of documentation identifying the driver as a sitting county judge for the full 11 minutes of the patrol car review. It was thorough. It was the kind of document that the Internal Affairs Office could not receive and route to the bottom of a stack. The complaint was received by Internal Affairs at 9:14 the following morning. It was referred to the Patrol Division's Professional Standards Unit by 11 o'clock. The Professional Standards Unit reviewed the dash cam footage from Elkins's patrol car. It was 12 minutes and 31 seconds of footage beginning from the moment Elkins activated his lights and ending when Judge Beaumont's enclave pulled back into traffic. The footage showed the lights going on the enclave signaling and moving to the shoulder without delay, the engine turning off, the hazard lights activating. It showed Elkins's approach the walk from the patrol car to the driver's side window, which took 18 seconds. It showed the window going down. It showed Judge Beaumont's hands, visible throughout at 10 and 2 o'clock, on the steering wheel, where they remained until he reached for the documents. It showed Judge Beaumont producing 3 items simultaneously and holding them through the window. It showed Elkins looking at the judicial identification card. It showed Elkins looking at it for 11 seconds. a measurable 11 seconds countable in the footage, longer than the license had taken, and longer than the registration had taken. It showed Elkins returning to the patrol car with all 3 documents. It showed 11 minutes and 12 seconds in the patrol car. It showed Elkins walking back to the driver's window. It showed him returning the documents and issuing a verbal warning. It showed Judge Beaumont writing something on a notepad, the badge number, the name, the time, and returning the documents to their places. It showed the window going up. It showed the enclave pulling into traffic. The footage was clear. The Professional Standards Unit reviewed Elkins's 4-year stop history. The stop history was 1,214 traffic stops in 4 years, which was the highest stop rate in the unit. The stops had been reviewed quarterly for officer safety compliance and had been consistently flagged as compliant. They had not been reviewed for distribution patterns. The Professional Standards Unit reviewed the distribution patterns. 2 investigators spent 3 days on the analysis. They looked at the stops by time of day, by location, by stated reason, and by the demographic profile of the individuals stopped. They looked at the citation rate for each subgroup and the arrest rate and the rate of stops that produced no citation or charge of any kind. The numbers were not ambiguous. The report of that review was 11 pages. It was not a comfortable 11 pages. Elkins was placed on administrative duty pending a full review of his stop practices. The review took 6 weeks. The result of the review included additional training requirements, a performance improvement plan, and a change to the unit's protocol for quarterly stop pattern reviews, which would henceforth include demographic distribution analysis alongside safety compliance review. The change to the protocol was the thing Judge Beaumont read most carefully in the summary. He had read the individual outcome, the administrative duty, the training requirements, the performance plan, and he had understood it as the response to a specific officer in a specific situation. That response was appropriate and necessary. The protocol change was different. The protocol change was structural. It meant that the distribution analysis that had revealed the pattern in Elkins's 4 years would now be conducted routinely across the unit every quarter. It meant that the next Trace Elkins would have his pattern identified at 90 days rather than 4 years. That was the thing that mattered most. Judge Beaumont was informed of the outcome through the court's administrative channel, not through any direct communication with the police department. He received the summary on a Friday afternoon. He read it in his chambers. He set it down. He thought about the 14 cases on the morning docket on the day of the stop and about the attorney from Beaumont who had driven 2 hours for a proceeding that had been delayed 11 minutes because of a stop that had no legitimate basis. He thought about the 1,214 stops. He thought about the stops that had come before his stop on roads and at hours, and to people who had not had a judicial log, who had not had a Margaret Crane, who had not had 14 years on the bench, and 11 years before that, building a record that meant something in the county legal system. He thought about them for a long time. He thought about a specific case from his 3rd year on the bench, a young man who had been stopped 9 times in a single year before the case that came before him. 9 documented stops, none resulting in charges, each documented in the department's records and never aggregated, never reviewed as a pattern, because no one had looked at the same individual's stop history across the calendar year. He had presided over the case that resulted from the 10th stop, a case in which the young man's attorney had pulled all 9 prior stops as part of a pattern of conduct argument, and the pattern had been compelling enough that Harold Beaumont had allowed significant latitude in its presentation. He had thought about that case more than once over the years. He had thought about the 9 stops. He had thought about the young man's face when the attorney laid out the 9 prior stops in sequence on a chart. He had thought about what 9 stops in a year meant for a person's relationship to the road they drove on, to the time they spent on it, to the calculations they made before they got behind the wheel. He had heard the argument. He had allowed the evidence. He had ruled as the law required. He had not been able to do anything about the 9 stops. He thought about the 1,214. He thought about all the people who were on that list who were not him, who had not had a Margaret Crane, who had not had a judicial log, who had not had the institutional position that made a complaint possible in the way that it had been possible here. He thought the record of 1,214 stops existed before mine. The pattern was in the record. My stop added one more data point. He thought what my stop added that the prior stops had not added was a complainant with the institutional access to require the pattern to be read. He sat with that for a long time. Then he opened his judicial log. He wrote the date. He wrote what he had received and what it said. He wrote what the professional standards review had found. He wrote the record of 1,214 stops existed before mine. The pattern was in the record. My stop added one more data point to a pattern that was already complete. What my stop added that the prior stops had not added was a complainant with the institutional access to require the pattern to be read. He wrote, "This is not a record I wanted to add to." He wrote, "I am glad the record is now being read." He set down his pen. He thought about his father Walter, who had walked his mail route for 41 years and had given him the protocol when he was 16, not because Walter wanted to, but because Walter understood that not giving it would be the greater failure. He thought about the conversation, not its content, which he had known for decades, but the shape of it. His father sitting at the kitchen table after dinner with a cup of coffee, speaking with the specific deliberateness of a man who is choosing every word. The kitchen in the house on Millbrook Street. The particular light of that kitchen in the evening. His father's hands on the table. He thought about something his father had said that he had not fully understood until much later. Not the protocol itself, but a sentence that had come after the protocol at the end of the conversation. In the specific way his father ended conversations that were difficult by saying the thing he wanted to be remembered. His father had said, "You are going to do things I didn't get to do. You are going to be in rooms I didn't get to be in. But you are going to need the same things I needed to get through a traffic stop. I need you to understand that those two facts are both true at the same time, and that neither one cancels the other out." He had been 16. He had understood it intellectually. He was 63. He understood it completely. He was a sitting judge of the Callaway County Superior Court, and he had needed the protocol this morning, and the protocol had worked, and the record had been kept, and the pattern in the 1,214 stops was now being read. Both facts, true at the same time, neither one canceling the other out. He thought my father had that conversation with me because someone had had it with him. Because it was necessary. Because it had always been necessary. And the necessity had been transmitted from one generation to the next like a skill, like a trade. Like something you learn because you will need it. He thought the Professional Standards Review found a pattern that has been producing that necessity for 4 years in this county. Every person in that pattern, every one of the 1,214 stops, were the ones that matched the demographic distribution the review identified. Every one of them either had the protocol from their fathers or they didn't, and either way they were on that list. He thought, I am a judge. I preside over cases that are downstream of traffic stops. I have been presiding over cases that are downstream of Trace Elkins's traffic stops for 4 years without knowing it. He thought, I know it now. He thought the question of what I do with knowing it is a question I have some authority over from this side of the bench. He thought about that for a long time. He thought about the cases in which stop pattern evidence was admissible. He thought about the motions that had come before him on that question, the ones he had granted and the ones he had declined, the ones that had been argued well and the ones that had not been argued well enough to succeed, even when the underlying point was valid. He thought about the difference between evidence that is presented as a pattern and evidence that is lived as a pattern, and what it means for a judge to understand both sides of that difference. He had presided in his 3rd year on the bench over a case in which the defense attorney had used stop pattern data to challenge the basis of a stop. The data had been compelling. The legal argument had been technically sound. He had ruled in the defense's favor on that specific motion. He had never spoken about it outside the case, but he had thought about it afterward, about what the data represented and about the people behind the numbers, the individuals who had been stopped and who had continued about their lives, mostly without filing complaints, without the institutional access to make the numbers visible, without a judicial log or a Margaret Crane. He had known in an abstract sense for a long time what the numbers represented. He knew it less abstractly now. He thought about what his father would say to the work from where you are. You are a judge. A judge's work from this position is specific and bounded by law, and within those bounds there is more room than people think if the judge knows where to look. He thought, I know where to look. He thought about that for a long time. He closed the log. He had a 4 o'clock hearing. He had 3 cases in the afternoon session. A bail review, a plea entry, and a scheduling conference on a civil matter that had been pending for 7 months, and that both parties wanted to move forward on, but whose attorneys had been unable to find a mutually agreeable date for the next hearing. He handled the bail review first. The defendant was a 26-year-old man who had been held for 6 days on a charge that, upon review of the circumstances, Harold Beaumont found significantly overstated relative to the risk posed and the offense alleged. He reduced the bail to a figure that was achievable. The man's attorney thanked him. He did not acknowledge the thanks, not because it was unwelcome, but because thanking a judge for a correct ruling was a habit that he found understandable, and that he also found created a dynamic he was not interested in reinforcing. A correct ruling is not an act of mercy. It is an act of law. The plea entry took 12 minutes. The scheduling conference took 22, which was longer than he had allocated, but necessary. The attorneys had a genuine conflict that required him to listen carefully and mediate between competing legitimate scheduling constraints before arriving at a date that both could accept. He found the date. He set it. He noted it in the record. He finished at 5:21. He sat for a moment in his chambers before putting on his coat. He had a habit at the end of court days that had been significant in some way of sitting for a few minutes before leaving. Not meditating, not reflecting in any structured sense, simply sitting in the chamber that had been his for 14 years, with the desk that he had organized to his specifications, and the bookshelf that held the reference texts he used most frequently, and the framed photograph of his parents on the wall beside the window. His parents, Walter and Adeline Beaumont, on the front porch of the house on Millbrook Street. The photograph had been taken on the occasion of their 40th wedding anniversary by his sister, Carolyn, who had a talent for photography and who had taken over the years the photographs that the family actually looked like itself in. His parents were sitting side by side, his mother in a yellow dress he remembered from many occasions, his father in the dress shirt he wore when he was not wearing his uniform and wanted to look right. They were not looking at the camera. They were looking at each other. He had put the photograph in his chambers in his first year on the bench. He had never moved it. He thought about them now. He thought about the mail route and the red pen and the kitchen table and the protocol. He thought, they built me to be in this room. They built me to be someone who has the authority and the discipline and the record to do something about what the Professional Standards Unit found today. He thought that was what they were building, even when they didn't know they were building it. He put on his coat. He put on his robe. He went to the bench. The docket was 3 cases. He knew all 12. He had read the files the night before. He moved through the morning with the specific efficiency of a judge who respects the time of everyone who appears before him and understands that efficiency in a courtroom is not the absence of care, but a form of it. He finished the afternoon at 5:47. He stayed in chambers until 6:15, reviewing the files for the following morning's docket. He did this most evenings not because he was required to, but because the preparation was the difference between a judge who was ready and a judge who was adequate, and he had decided a long time ago which one he was going to be. He walked to his car. He had been walking this route from the courthouse on Caldwell Street to his parking spot on 9th 4 blocks for 14 years. He had walked it in every season and in every kind of weather that Callaway County produced, which was considerable. He had walked it after easy days, and after hard days, and after the days that had required him to make rulings that he had thought about for weeks in advance and continued thinking about for weeks afterward. He had walked it after the day of the stop on October 9th after arriving 13 minutes late and finishing a clean morning session and dictating his judicial log entry during the lunch recess and handling 3 afternoon cases and reviewing the next day's files. He walked it now on the Friday afternoon when the summary had arrived. He thought about what 14 years of this walk had built. He thought about the specific knowledge that accumulated from presiding over the same community's legal matters for 14 years. The patterns in the case types. The patterns in who appeared before him. The patterns in who was represented and how well and what happened to people who were not well represented. He thought about the work he had done to be prepared for every case and about the cases that had required more than preparation and about the cases that had changed his understanding of the law and of the system the law was part of. He thought about the 16 notebooks, the first 15 in the filing cabinet, the 16th still in use. He thought 16 notebooks is a record. He thought the record is going to be useful. He thought about his mother Adeline with her red pen and her cup of tea grading papers on the kitchen table on Sunday afternoons. He thought about what she had said when he had asked her once why she bothered. Why she wrote detailed comments on every paper when most students only looked at the grade, and the comments were almost never read. She had said they are read by the right person at the right time. The work is to write them clearly enough that when the right person reads them, the comment does its work. He had thought about that comment many times. He thought about it now, standing in the parking lot of the Callaway County Courthouse about to drive home on the Meridian Expressway. He thought the 16 notebooks are comments, written clearly, for the right person to read at the right time. He thought, I'm going to make sure the right people are reading them. He got in the car. He thought 16 notebooks. He thought the right person reads them at the right time. He started the engine. He drove home on the Meridian Expressway. He passed the exact point where the stop had occurred. He had been passing it every morning and every evening since October 9th. He passed it on the day of the stop. He passed it the day after when Margaret's complaint had already been filed. He passed it during the 6 weeks of the professional standards review. He passed it on the Friday he received the summary. He noticed it every time. Not dramatically, not with dread, not with anger. With the specific noticing of a man who has decided that the thing that happened in that spot matters, and that the act of driving past it is a form of keeping the memory in its correct place, which is present, specific, named, and counted. 14 years of driving this route. 7 stops in 14 years on the bench. The protocol at 10 and 2 every time. He drove at 61 miles per hour in the right lane with his hands at 10 and 2 and his eyes on the mirror. He thought about the protocol he had been following since he was 22 years old. He thought, I have been doing this since before the law was mine to administer. He thought the law is mine to administer now. He pulled into his driveway at 6:23. He went inside. He had dinner with his wife Claudette, who had been married to him for 34 years, and who had been through the stops with him, not in the car, but in the kitchen afterward. In the specific way of a person who has spent 3 decades being the person her husband came home to after these experiences, and has developed over those decades the precise skill of knowing when to speak and when to be present without speaking, and when to ask the question that opens the thing that needs to be opened. She had asked the question on the evening of October 9th when he came home, how long? He had said 11 minutes. She had said nothing. He had said, I called Margaret from the shoulder. She filed the complaint the next morning. She had said good. That was the conversation they had had on the evening of the stop. She had not asked for more than he offered. She had offered nothing unnecessary in return. That was 34 years of knowing each other, the specific economy of a long marriage between 2 people who have learned how much of anything the other one can carry on a given day and who have learned to give each other the correct amount. Now it was the evening when the professional standards summary had arrived. He came home at 6:43. She was at the stove. She said, how was court? He said, good. 14 cases. Clean morning. 3 in the afternoon. She said, and the rest. He said, I got a summary from the professional standards review. She set down the spoon. She said, and. He said, they found what they found. They're making changes. She said, changes. He said, to the protocol. And to Elkin specifically. Administrative duty. Training requirements. Performance plan. She said, "Is that enough?" He sat with that for a moment. He said, "It is the beginning of enough. Whether it becomes enough depends on what happens next, which I don't control from this side of the bench." She said, "But you do from the other side." He said, "Yes." She said, "Then that's something." He said, "Yes, it is." He picked up his fork. He ate his dinner. Claudette had her own account of the 34 years, which was different from his more external, more visible in some ways, and less visible in others. She had watched him pull into the driveway on evenings when something had happened, and she had known from the pace of the car in the driveway and the specific way he came through the door that the evening was going to require a particular kind of attention. She had provided that attention for 34 years. She had never once suggested he respond differently. She had never suggested that the protocol was not worth maintaining, or that the documentation was excessive, or that the correct channels were not worth using. She believed in correct channels. She had spent 22 years as a social worker, which had given her, if anything, a more precise understanding than his of what happens when correct channels fail, and an equally precise understanding of what happens when they are used correctly by the right people at the right moment. She said, "Harold." He looked up. She said, "The 1214. He said, "Yes." She said, "Those were real people." He said, "I know." She said, "And your stop is the reason someone finally looked at the list." He said, "Yes." She said, "That's not nothing." He said, "No, it is not nothing." She said, "Eat your dinner." He ate his dinner. After dinner, Claudette went to read. Harold went to his study, a small room at the back of the house with a desk and a bookshelf and a window that looked onto the yard and that he had used throughout his career as the room where he thought about things that were not resolved by the end of the working day. He sat at the desk. He thought about Margaret Crane, who had filed the complaint in her own name and in her own professional capacity because she understood that his conflict of interest made it complicated for him to file directly, and who had done it the morning after, without being asked again. He thought about Margaret's 27 years in the court system, which had given her a precise understanding of what institutional processes could accomplish when used correctly and by the right person at the right time. He thought about the specific thing she had said when he told her about the stop. Not, "I'm sorry." Not, "That's terrible." Not anything that placed the weight of the experience on him to carry. She had asked 3 questions. She had gotten the information she needed. She had said, "I will file a complaint." And she had filed it. That was what it looked like when someone understood their role in the institution and used it correctly. He thought about what his father would have said if Harold had told him, "I became a judge and I got stopped on the way to court and my assistant filed the complaint and the professional standards unit reviewed 1,214 stops and found a pattern and changed the quarterly review protocol." He thought his father would have sat with that for a moment, would have looked at his hands on the table, would have said both facts, true at the same time. He opened the drawer of the study desk. He took out the personal journal he kept at home. Different from the judicial log, different from the bench notes, the journal that was his alone and not any institution's. He wrote the date. He wrote the summary arrived today. 11 pages. The protocol changes to quarterly demographic analysis. Both the immediate response and the structural change. This is what the correct channels produce when used by the right people at the right moment. It is not enough. It is not nothing. He wrote, "Walter gave me the protocol at 16. I have used it for 41 years. I used it this morning on the Meridian Expressway, and the protocol worked, and the record was kept, and the pattern was found." Both facts. True at the same time. Neither canceling the other out. He wrote, "Claudette said the 1,214 were real people. She is right. They are real people. I have seen the downstream of stops like theirs in my courtroom for 14 years. I am a judge. I have tools. I know where to look. I intend to look there." He wrote, "The quarterly protocol change takes effect beginning with the next review cycle. The first analysis under the new protocol will cover the months of October through December of this year. The results will be reviewed in January." He wrote, "I will be on the bench in January." He set down his pen. He closed the journal. He turned off the study light. He went to bed. Outside, the October evening settled over the Fairview neighborhood, the way October evenings do cool Pacific, the year beginning to turn toward its close. The courthouse was 14 minutes away by car on the Meridian Expressway, the route he had driven for 14 years, the route he would drive tomorrow morning and the morning after that, and the morning after that, with his hands at 10 and 2 and his eyes on the mirror and his judicial robe in the back seat for quick transition. He had started keeping the record, not this year, not on October 9th. He had started keeping the record when he was 22 and had been pulled over for the first time and had come home and written down the date and the time and the officer's name and the badge number and the stated reason for the stop in a notebook he had bought for this purpose because his father had given him the protocol, and the protocol included document afterward. He had been keeping the record for 41 years. What had changed on October 9th was not that the record began. What had changed was that the record had been read. For 41 years, Harold Eugene Beaumont had kept it. For 41 years, no one had been required to read it. On October 9th, someone finally was. Subscribe our channel. We tell the stories of the people who decide to start keeping the record.